All right, looks like the meeting is now streaming live. Is that correct? All right. At this time, this court does begin the continuation of the Kansas Court of Appeals docket held in Johnson County. Earlier this week, we heard arguments live at the Johnson County Courthouse, and we appreciate the hospitality. Today, we hear virtual arguments in the third case that was originally set on the docket. My name is Judge Rachel Pickering, and joining us on our panel today is Judge Tom Malone, who has served with the Court of Appeals, Kansas Court of Appeals since 2003. And serving on the panel is Judge Sarah Warner, has been with the Court of Appeals since 2018. Just one quick housekeeping matter. Our court's website purposely lists all the dockets for the remainder of the year. So if you believe you have an appointment commitment that may conflict with the future docket, please reach out to our appellate clerk's office. And that way we can set our dockets and be mindful of your potential scheduling conflict. So at this time, we do now call case number 126536, TR versus University of Kansas. If I could have the parties please state their appearances, starting with the appellant's counsel.
Good morning, Your Honor. Maureen Brady on behalf of plaintiff appellant.
Thank you.
Good morning, Your Honor. Michael Raup on behalf of the appellee.
Thank you. Ms. Brady, how much rebuttal time would you like to have?
I would like to reserve 3 minutes of rebuttal time.
All right, and we have you set for a 15-minute docket?
Yes, Your Honor.
Okay, good. All right, with that, you may begin, Ms. Brady.
May it please the court. This court should reverse the March 1st, 2023 journal entry entered by the district court, as the district court incorrectly found that Kansas does not recognize a duty of confidentiality of medical information or a right to maintain a court action for violation of that duty. 4 issues have been brought before this court. Number 1, does Kansas impose a duty of confidentiality of patient medical information on healthcare providers? Number 2, does Kansas recognize an action in tort against a healthcare provider who wrongfully discloses medical information? Number 3, does KU Medical Center have sovereign immunity because maintaining confidentiality is a discretionary judgment call on behalf of the healthcare provider? And number 4, does KU Medical Center have sovereign immunity because it failed to enforce HIPAA? The facts of the underlying case are fairly straightforward. Plaintiff went to KU Medical Center for a very sensitive pelvic exam. While in the exam, plaintiff was naked from the waist down and her feet were up in stirrups. While her legs were open, the doctor that was examining her took out her personal cell phone and, without the permission of plaintiff, took a picture of plaintiff's splayed genitals. The doctor then texted a copy of that photograph to 2 student physicians who were also in the exam room, all done without plaintiff's permission. For this, defendant KU Medical Center and the doctor, the student's employer, claims that it has no duty to keep plaintiff's medical information private. The journal entry from the district court incorrectly states that defendant has no duty of confidentiality to its patients. While plaintiff admitted there is no on-point case, the absence of precedent does not mean that the duty does not exist. In OMI Holdings versus Howell, the Kansas court recognized that the novelty of a claim and the absence of precedent does not establish that the cause of action doesn't exist. Prior to the implementation of KSA 60-427, the Kansas court in Wesley Medical Center versus Clark stated that at common law, there was no physician-patient privilege, and the physician has, as well as the client, would be compelled to testify as to communications, even though they were confidential. Kansas recognizes this duty of confidentiality throughout its common law and its statutory scheme. The likely reason that there is no on-point case about privacy, particularly medical privacy, is that medical privacy is a basic human right. It is intrinsically pervasive through common law and statutory law. Medical privacy is a
Counsel, if that is the case, then how is it, if it is in fact a basic human right, how is it that there was no common law restriction or on compelling a physician to testify?
I'm sorry, Your Honor, can you
Yeah, just a minute ago, you said that, but before we had the doctor-patient privilege that has been codified evidentiarily in our statutes, that there wasn't a common law restriction on that. And I'm just wondering how you reconcile that with your allegation that patient privacy is a fundamental human right.
It is a fundamental human right, and the Wesley court stated that the information was confidential. It just hadn't been codified at that point. And so confidentiality was intrinsic. It was in the background. It was the understood basis. It's those ideas that the right is there. The duty of confidentiality is there. It just had never been codified or even recognized specifically. Just because there has not been any precedent on the issue doesn't mean that there wasn't the duty. Medical privacy is essential to personal autonomy, individuality, respect, dignity, and our worth as human beings. However, that a case on point saying those words doesn't necessarily exist in Kansas. That doesn't mean that it doesn't exist. And I'm not sure if I answered your question.
Yeah, I think so. The problem that I am seeing that you, in your brief, you point to a number of statutory provisions, federal and state provisions that have to do with confidential information, but those are specific articulations of a specific incident. They're not broader articulations of a penumbra of rights. And so I'm just wondering how we jump from those statutes to this notion that there is a common law tort for a common law duty not to provide information.
Okay, I'm with you. And here's how we get there. Because even the defendant has recognized that it has a duty of privacy. I'm stunned that it has made the claim that it doesn't have a duty of privacy. Its own policies and procedures that it puts out on its website, that it gives to patients when they come into their facility for treatment, states, our commitment to you, KU Medical Center, strives to protect your medical information. The law requires us to keep your medical information private.
But that's a statement under HIPAA, right? I mean, that's a HIPAA statement.
That is one of the HIPAA statements. However, HIPAA is a procedural statute. All HIPAA does is provides healthcare providers direction, rules and regulations of how information should be kept private. HIPAA recognizes, the omnibus rule recognizes that confidential information between physician and patient should be kept confidential. HIPAA just comes along and tells healthcare providers, we understand that there are circumstances where you should and can release information. We're going to give you those rules and regulations. HIPAA is for the protection of healthcare providers, not individuals. There are no individual rights.
Counsel, wouldn't you agree that the opposing party does not disagree with your statement about the rights that HIPAA provides to patients?
Correct, Your Honor.
They're agreeing that HIPAA does give those rights, but I'm still struggling with the right that you're saying it now gives as a breach fiduciary duty of confidentiality. And what I'm struggling with that is under KSA 60-5201, it says, the intent of the legislature is that no statute, rule, or regulation or other enactment of the state shall create a private right of action unless such right is expressly stated therein. So that to me says this is the intent of the legislature, that we are not creating a private right. And that's where this district court judge said, we don't see that. So how can you, how do you get over the hurdle of KS 60-5201, please?
Your Honor, I don't even think it comes into play because we are not asking for a private right of action under HIPAA. HIPAA, again, is a procedural statute only. It only says how information should and can be released. It is for the protection of the healthcare provider only, because it carries with its penalties. It's a criminal statute. It carries criminal and civil penalties that can be imposed by the Office of Civil Rights. That is not what we are claiming here. What we are claiming here is a tort cause of action, breach of fiduciary duty of confidentiality, negligence causes of action. Where the district court erred is that it didn't recognize a duty of confidentiality when KU Medical Center even recognizes its own duty of confidentiality. The violation of those policies and procedures is a negligence cause of action in tort. So there is a recognition that there's a tort cause of action for a breach of a breach of confidentiality. It's a chicken and egg argument, if you will. Just because there's no existing case law doesn't mean that the duty doesn't exist. And every negligence cause of action would, if that were the case, every negligence cause of action would have to be exactly the same as the negligence cause of action before it.
So let's look then at the statute 60-427, physician-patient privilege. Okay, right? And I know opposing counsel will do the same. Subsection A4, confidential communication. Are you saying from our reading of that portion of the statute that creates this tort action?
Your Honor, it doesn't create the tort action. It recognizes that information should be kept confidential. The statute doesn't create a tort cause of action intrinsically. It talks about waiver of privilege, but the existence of a tort cause of action is in the negligence field, where a healthcare provider wrongfully discloses medical information either in violation of their policies and procedures, which just happen to be compliant with HIPAA. KU Medical Center has compliant compliant policies and procedures. HIPAA is just a way to reference those policies and procedures because they are compliant. So they should be symbiotic with one another.
Counsel, you have about a minute left of your.
Oh, I'm sorry. Okay, Your Honor, I will quickly touch issue 3 and 4, sovereign immunity. The district court erred in finding that defendant had sovereign immunity for discretionary acts. Maintaining privacy is a mandatory act, not discretionary. Further, issue 4, the district court found that the defendant is entitled to sovereign immunity for enforcing or fail to enforcing the law. KU Medical Center does not enforce the law. That lies wholly with the Health and Human Services Office of Civil Rights. Sometimes it can go to the Federal Trade Commission. However, enforcement of the law is not within KU's purview. And for the foregoing reasons, this court should reverse the journal entry of the district court dismissing plaintiff's case.
Thank you, counsel. You'll have 3 minutes of rebuttal. Thank you.
Thank you.
All right, Mr. Rawl.
Thank you, Your Honor, and may it please the court. At the outset, I want to be clear that the case we have here does not involve an alleged breach. It does not involve alleged unauthorized access to a photo or any records. And there's no allegation that anyone outside of plaintiff's care team ever had access to any of the information. And as plaintiff is now admitted at pages 14 to 15 of the reply brief, all this case is about is the method that the doctor used to transmit this photo, that being allegedly through a text message. And the claim here is that that's not a secure enough method of communication, and therefore made that information vulnerable to some hypothetical breach that is not alleged to have ever happened. Yet, despite those, that there's no unauthorized access alleged or any other tangible harm, the claims made that Kansas law recognizes a separate tort cause of action, a separate tort duty, allowing a claim for money damages on this basis. But as plaintiff admits, and as she did before the district court, no Kansas court or any court applying Kansas law has ever adopted the legal theory that she advances here. And that's fatal for two reasons. First, it means there's no legal duty for purposes of just stating a claim in the first place, no actionable legal duty. And second, it means that because there is no recognized tort theory that currently exists, the medical center is entitled to sovereign immunity. And I think that those...
So your opposing counsel has made the allegation that, you know, the fact that we don't have a case on point at this point doesn't mean that Kansas courts might not recognize a common law cause of action, and that happens from time to time where we'll recognize a common law cause of action. I was wondering if you could respond to this notion that kind of within the Kansas statutes, there's a recognition that healthcare professionals have this sort of a duty.
Well, I have a couple of responses to that, Your Honor. First, getting to the specific statutory provisions, some of which Judge Pickering was discussing as well. None of those statutes create any sort of private right of action. And as Judge Pickering noted, there's also the Kansas Express statute that says unless we create a private right of action, there's not one there. And if we allow negligence law to step in and subsume that, you render that statutory prohibition superfluous, because we can characterize any statement in any statute then as a duty under negligence law. So I don't think that gets around it. But I think what's important
Can we pause right there? Can we pause right there? I
Sure.
think that's something I wanted to discuss. If we agreed with the appellant's argument, would we be opening the door for future negligence actions to be brought against any duty besides just the duty between a physician and a client and their patient?
I believe you would, because I think that's the only source, or that's the source that they've cited that I suppose gets closest to this duty of confidentiality. Again, it's never a duty that runs to the medical center, right? Like that's not part of this either. So I think that's another hurdle they have to get over. But I don't see what the limiting principle would be if you take that step here. And I'd also say, Judge Warner, in response to your question, we don't contest that there are circumstances where the courts can adopt new theories, right? Or new legal theories. That can happen, and as you rightly point out, does happen from time to time. I think it's problematic in the sovereign immunity context, however, because the state has sovereign immunity so far as there is not a recognized tort action that would lie against private parties as well. And so if you look to the Prager case, for example, from the Kansas Supreme Court, there the court says, because the plaintiff has not cited a case where we have adopted this as a legal theory, we can't do so here. And that's a rule that makes sense in the sovereign immunity context, because what the legislature is doing with the Kansas Tort Claims Act is putting the state on notice of the things that it can and cannot be held liable for. And so it only makes sense then and would follow that until there's a recognized cause of action that exists by creation of the legislature or by some judicial adoption in a case that preceded the conduct here, you don't have liability. And the only case that plaintiff cites to attempt to get around this is the Hill versus State case that's discussed in the reply brief. But the problem with Hill is I think it actually supports the medical center's view in this case, because there the court focused on the plain language of the KTCA and that provision about a private party being liable under the laws of this state. Hill involved a retaliation claim, and the question was whether the retaliatory act had to be discharge or demotion, or if it could be something short of that in order to qualify for retaliation for civil servants. And the court went through its analysis and said, yes, we think it can be something short of that. And the reason that sovereign immunity didn't stand in the way was because the court recognized that for a long period of time in the private sector, courts have always recognized retaliatory acts short of those as being actionable. So in other words, it's the inverse of what we have here. Here you have no legislative enactment, you have no common law duty that has ever been established by any Kansas court. And so I think this is a route that the court could take and should seriously consider, because I think the fact that there isn't a recognized cause of action grants qualified immunity to the medical center. And I don't think the court would need to go further if it made that ruling. I don't think it would need to articulate whether there was some sort of hypothetical duty of confidentiality, what circumstances that would apply in. And again, this ties back to what I opened with, that we have a cause of action here alleged that goes far beyond even what any of these other states that plaintiff cites were to do. All of those state statutes relate to unauthorized access to a third party, right? A third party has breached records, has taken medical information. Here, I guess we're attempting to adopt a cause of action that would regulate the method of communication that's used. I'm not aware of that type of private common law cause of action being adopted in any state. And that ties back to the fact that it is specifically articulated in HIPAA, right? And HIPAA expressly, of course, as we all know, doesn't create the private right of action. And that's the difficulty that's created by this situation for plaintiff.
Counsel, I was reviewing the journal entry by the district court judge. Is there any portion of that journal entry that you believe disagrees with your argument?
That I believe disagrees?
Correct.
There is certainly a part of the journal entry at the end where the court says that it didn't need to reach other arguments that we had raised for dismissal. On the immunity points, I don't believe so.
But the rest of it, you do agree?
Yes, we agree. Yes, we agree with the rest of it, that those would all be appropriate bases on which to affirm the district court. Yes. Again, I think there's several paths that the court could take to get there. One is, I think, as I said, just to say, sovereign immunity exists here and we don't need to go further. Then I think the next layer would be, even if we do go further, then we look to whether we should adopt or create this private right of action that's alleged here. And I think then you look to the most important thing that this court should look to is the Kansas federal court's decision in Link versus Lawrence Memorial Hospital, where Judge Melgren looked at this exact issue, whether there was a duty of confidentiality under Kansas law, and specifically ruled that there was not, looking at common law, looking at statutes, looking at that case even alleged the Hippocratic Oath could be a basis for this duty. And Judge Melgren says that none of those create a duty under Kansas law. And so, of course, while this court wouldn't be bound by Judge Melgren's decision, it's the only Kansas case or only case applying Kansas law that has looked at this issue, and it specifically ruled on this. And there's no answer from plaintiff to that in the reply brief. I think that's supported by the other states that we cite on pages 16 to 17 of our briefing that articulate this same principle applying across several states, Tennessee, Ohio, Indiana, where the courts are looking at this exact type of alleged cause of action and saying that just merely taking HIPAA and saying, well, that provides a duty of care, that doesn't work because it's an end run around what Congress did when it said there's no private right of action. And I'll loop that back as well to your point, Judge Pickering, about the Kansas statute that prohibits private rights of action absent an express adoption. Of course, the Kansas legislature knows HIPAA, and it knows that it doesn't create a private right of action. And it is certainly within its purview to create its own statutory paradigm and create a private right of action or not create a private right of action.
Right, and that's why I asked, move to KSA 60-427 on physician-patient privilege. Like, if they're going to create this right of action, why didn't they put it right there, right after they discuss confidential information?
If they were going to create a private right of action, that's where they would have done so, and they chose not to. And the statute you cited, 60-5201, is a pronouncement saying that when we don't speak and when we don't create a private right of action, we mean not to. And so if anything, I think that's a stronger argument that there's no private right of action that exists when there are. And again, I would still certainly quibble with the point that that's the relevant statutory provision, because we're not, again, the cause of action here is about the methodology that's used to transmit this material to somebody else on the care team. So I'm not sure that invokes any sort of confidential communication privilege in any event. But even if it did, there's no private right of action there. Fourth, or finally, on the sovereign immunity point, and I recognize that I'm probably running up against time here, but I want.
You have about 3 minutes, so you have
3 minutes. Okay, perfect. And I think that this is a point that loops back to the whole argument about whether this is the right case in which to take on this. What is the duty? Where does it exist? I think there's going to be an issue that runs headlong into the court standing doctrine if we're adopting a damages cause of action in this sort of circumstance. Because as we cited, I think it's footnote 5, it's one of the footnotes in our brief, when you have these true data breach type cases where you have allegations that a bad actor has come in and a healthcare facility, for example, has failed to safeguard information, and a bad actor has come in and taken that information. There are several federal court decisions that are saying there's no injury in fact in that circumstance if there's not an allegation that something has been done with that information. It's not merely enough that the information has been taken. If there's no negative consequence or nothing has alleged to have been done with it, there's no standing. And of course, Kansas, at least as to the injury in fact component of standing, will look to federal law and will borrow from federal law in determining what's a proper injury in fact. And so I say all of this not to suggest that I think the court should dismiss this case for lack of standing or anything like that. But I think it counsels for how far we should go down this path of creating a new private right of action, when the court would have to articulate what the damages theory under that cause of action would look like, and in my view would inherently run into some of those standing problems. And I think that counsels for what we began with, which is perhaps the most efficient route for decision here, is to look to the sovereign immunity inquiry and to base it on the recognition by all parties here that there's no Kansas cause of action or no articulated cause of action that exists under statutory law or under common law at this point in time, and resolve it on that on that immunity basis. Judge Pickering, am I close?
You have 30 seconds if you wish to wrap.
Okay. The last point I'll make real quick is just on everything else I think is captured in the briefing. But the discretionary function immunity, I think, is an important component if the court needed to reach that as well, because I don't think there's any articulation, that certainly nothing beyond HIPAA, that would articulate the precise manner of communication that would need to be used to transmit medical information to other members of a care team. And so to the extent there's not a mandatory duty that's established, certainly not one beyond HIPAA, I think that immunity would apply as well. Again, I don't think the court needs to get to any of those exceptions to KTCA to resolve this case, but if it does, I think that's the clearest example of where we should get. And for those reasons, we believe that the judgment of the district court should be affirmed.
Thank you, counsel. All right, with that, Brady, you have...
Thank you, Your Honor. May it please the court. To address a couple of issues, the first one regarding the duty that runs the medical center of confidentiality. That confidentiality is administrative duty that is applicable to all of its employees, as it states in it, as KU Medical Center states in its own policies and procedures. The providers who must abide by their privacy duty include employees, staff, trainees, volunteer groups, and other healthcare workers, because it is applicable to all of KU Medical Center and its subsidiaries. Privacy is an administrative duty. Mr. Ropp said that he did not know of any third-party breach that recognized a common law cause of action. I could name him almost every state in the union, with the exception of Kansas, that has a common law case addressing negligence, breach of fiduciary duty, particularly in Missouri, which is cited in the briefing, that there is a duty that a patient will maintain when disclosure of information is incorrect or did not follow the requirements of authorization. Further, Mr. Ralph cites to the Hill case. The response to that is that it is not analogous here. The Hill case was about creation of a private cause of action through HIPAA. Again, we are not claiming that. HIPAA does not give a private cause of action. HIPAA is for the benefit of the healthcare provider only. This is a negligence cause of action.
I would take a minute on to Judge Melgren's analysis in Link.
I'm sorry, say it again, one more time.
Could you take a minute and explain why you believe Judge Melgren's analysis in Link is incorrect?
The analysis was looking for a private cause of action within HIPAA itself. And it was not, the way that case was formulated, it was not showing a negligence cause of action. HIPAA does not give a private cause of action. HIPAA is a procedural statute only. And consequently, the way that case was structured is not the same or analogous to this particular case. This case is a negligence cause of action that has other negligence type causes of action. Kansas has a duty of, or excuse me, KU Medical Center has a duty of privacy. The Kansas Tort Claims Act waives sovereign immunity where that duty of privacy has a recognized tort cause of action to any private person, and that's negligence. And also, Mr. Ralph cites to the CC versus MedData case regarding the standing issue. That actually is my case. That was a federal case that had very specifically to do with an Article 3 standing point. When we went back to Johnson County, that case has stood and survived a motion to dismiss.
Counsel, it's rebuttal time, so I apologize with the 3 minutes. Would you like seconds to wrap up your argument?
Yes, thank you. And for foregoing reasons, the court should reverse the district court. Thank you for your time today.
Absolutely, thank you. With that, take the matter under advisement, and we are adjourned at this time. And I appreciate the counsel's hard work preparing for today's arguments. Thank you.
Thank you.
Thank you, Your Honor.